So this morning we delve into antitrust law, which I dare say you probably haven't spent a whole lot of time in your life studying. You probably didn't have a class on this in high school. All right, there's really no equivalent in other sections or other classes. And to understand this particular topic, you kind of have to go back to why. Why do we have laws that prevent companies from working together and prevent companies from doing certain things in the marketplace? If you say that America has a free market, would you agree with that? We have a free market system. That's the idea, that we have a free market system. Some of you would say we have a modified free market system. And that's a more accurate description of the system that we really have, because a free market system would just sort of be, woohoo, do whatever you want, and that's clearly not what we have. We wouldn't have much of a class in business law if we just said, do whatever you want. That'd be the shortest class ever. We probably wouldn't be able to give you a credit for that class. And the problem with that's a sort of extreme libertarian approach. What are some problems with that? Where do you end up if you have a completely unfettered free market? What do you think, Fred?
Eventually you end up with a monopoly and control the price.
Okay, so you have price controls, but ultimately, so what? What's wrong with that?
Well, anyone who has power to take advantage of someone else will do it.
Well, I thought people were basically good. We're taught that in kindergarten. Chicken soup. You're a good person, Johnny. Johnny grows up, becomes the CEO of a monopolized company. He wouldn't misuse that power, right? Can't we trust people? Well, it seems that the people who think that man is basically good sort of throw that idea out the window when it comes to antitrust law, because they assume, as Fred does, that as soon as you have that power, you will abuse it, all right? There are certainly examples of both along through our history. Okay, so that's one aspect of antitrust law, but we'll go even broader. If we just didn't have any rules whatsoever that governed business, what other kinds of things might happen in society? Are we better off for that or less well off for that? Yeah?
Well, how in the world would you handle any lawsuit?
Okay, what about just basic relationships, right? And contracts and employment, and people make promises one day and break them the next, and there's just no consequences. There's no one there to be the adult in the room to say, stop it. You've got to honor your commitments. And so we understand the law has a proper place in the marketplace. Is there a point at which the government can go too far in regulating these things? Where would you say, what are some bright lines that the government shouldn't cross? Have you ever thought about that? Joel, you're going into politics. What are the bright lines, do you think, that the government just should never cross when it comes to interfering with business?
It's up to the business themselves, how the policies and stuff.
So the government should give businesses freedom to make decisions based on their best judgment of what they think they want to do and what they want to do with their life and with their business, right? That's what freedom's all about. Does that include not protecting people from bad decisions? To some extent, yes. Does that mean that, okay, you have the freedom to make your decisions and reap the consequences of those decisions? In other words, the freedom to fail. But what about all this business we heard a few years ago about they're too big to fail, that we have to bail out these companies? You understand there's a lot of these lines in here which we have said, if in a perfect system, this is where the lines would be, they should never, and then an actual case comes along, and we say, well, but maybe in this situation we shouldn't do that. Antitrust law is full of that kind of stuff, where we say, you know what, this is a bad situation. We need to come in and fix it. And sometimes the fix is worse than the situation it was supposedly fixing. And other times we feel like, man, it didn't go far enough. And so this is an area of law that was established. The main statutes in this area came into play in the early 1900s. And so we're looking at almost 120 years plus of law history over the same statutes, the Sherman Act and the Clayton Act, that we'll look at in detail in this chapter, that were passed in the early 1900s and are still the main laws governing this today. Now, we've had lots of case law, we've had lots of modifications, but to understand sort of the early history, in the 1800s, the only thing you could do was bring a common law action. Now, if you recall back, go back all the way to Law 1, all right, when we talked about legal systems, the common law is judge-made law, case law. No statutes, we're just talking about basic fairness and equity, common sense, if it exists, the cases that went before trying to have consistency and fairness. And so common law actions would be brought to restrain trade and regulate economic competition. And so people would come in and say, hey, this guy over here is doing business in an unfair way. Or then people started to try to abuse the system and get a judge to put their competitor out of business and thereby create a monopoly, or to restrain trade in some other ways. And so case by case by case, the Supreme Court was trying to craft rules that made sense in every situation. Now, you know that that's kind of a hard process. In fact, the process that the Supreme Court was undertaking in the late 1800s to combat the big companies back then. What were two industries that were really big about that time in history? Oil, steel, railroads, right? Those were kind of your big three, and really feeding off of each other. And so you had some, at the time, millionaires, okay, which they say, millionaires are a dime a dozen now, not necessarily on this campus, but in the real world. And so at the time, to be a millionaire was huge, and you had your Rockefellers, and you had your Standard Oil, and you had your Lehman Brothers, and other kinds of people who were just absolutely filthy rich. And some of that came from this kind of unfair competition. And with that kind of wealth, with that kind of power, came the power to abuse other companies and keep them out of the sectors that each company was in. And so the Supreme Court is battling against that, those very powerful forces. By the way, those guys were not only rich enough to manipulate business, they were also rich enough to manipulate government. And they were absolutely having their guys get elected in as governors, as legislators, and they even tried to get their guy in as president. And so the Supreme Court is saying, wait a minute, somebody's got to have some sanity. Somebody's got to look out for the little guy. And so that was the court. Now, what do we call judges that say, here's a problem in society, and we as a court need to try to go in there and make some rules to fix it? What do we call those guys now? What? Socialists? No, we have a name for judges like that. You hear it come up in confirmation hearings when a liberal comes up. What do they say? Oh, she's a what? No, she's an activist judge, right? Then we call them an activist, and we say it with she's an activist judge, all right? We say it with great disdain. And so that's exactly what the Supreme Court was. They were making laws left and right, and they really weren't even apologizing for it. And they were doing that at a time when it was still out of fashion for the Supreme Court to do that. Nowadays, it's just common practice, but back in the late 1800s, early 1900s, that was unheard of. We call that a legislative process. And the fact is, we have a branch of government that's set up to do that. And it's not the Supreme Court. And so eventually, the branch that was supposed to be doing this figured it out, and in 1890 passes the Sherman Antitrust Act. Okay? And we're going to spend all of today looking at one half of the Sherman Antitrust Act. And there's the second half of the Sherman Antitrust Act. So you have Section 1 and Section 2. And then in 1914, one little tweak, and they come in and pass the Clayton Act in 1914. And what this process did was almost entirely take the Supreme Court cases about antitrust and put them in as legislation. So they said, this is how we will embody, okay, that's the way the legal term used, we're going to embody this group of cases into laws and make it simply stated, and it will give us the ability to regulate this very important area. So what does the Sherman Antitrust Act look like? Well, it fits on one slide. And this is the whole deal. You notice that the laws that stand the test of time are not long. Okay? So what does that mean for Obamacare? Well, I hope it means what I hope it means. All right? And it's a very long one. This is a very short one. Very simple. Very to the point. And then on top of that, very complicated in its application. All right? Because the simpler it is, the more interpretation it could have. And the more difficult it can be sometimes in application. But it sets up two very basic principles. And it says, number one, every contract, combination, or conspiracy, they got the 3 C's in there, in restraint of trade or commerce, there's a 4th C, among the several states or with foreign nations is hereby declared to be illegal and is a felony punishable by a fine and imprisonment. Notice what they did there. They made a business practice a crime. They made it a felony punishable by fines and or imprisonment. Now, you say, I'm going to be a little more careful about what I'm doing in business if it could land me in jail. Being fined is bad enough. Losing my job is bad enough. Bankrupting my company is bad enough. But going to jail? No, thanks. Okay, I think I'll just maybe avoid that area. And so they say every contract in restraint of trade is a crime, is illegal and a crime. Now, why would they declare it to be illegal and a crime? Why would they declare it to be illegal and a crime? Well, who prosecutes crimes? We had this chapter already once this semester, a long time ago. Who prosecutes crimes? The state, the government brings those cases. If something is illegal in business and someone wants to have a lawsuit about that, they believe they're injured, who brings that case? Is it the state that brings a private civil action? No. It's the injured party brings that action. And so what this is saying is either one can file a lawsuit against a company for this kind of behavior. It's both a crime and a lawsuit, a civil lawsuit. It's illegal and it's a crime. Now, what exactly then is illegal? Well, we'll spend some time analyzing that. But what do you think the things in the first 2 lines, the 3 C's, contract, combination, in form of trust, or conspiracy, what do all those things have in common that we're looking for in terms of the types of restraints on trade that are embodied or prohibited in section number 1? What's unique about that? Or what?
It's a joint effort.
A joint effort. Okay, the old, it takes 2 to tango, right? It takes 2 to violate Section 1 of the Sherman Act. Just doesn't have the same ring to it. All right, it doesn't rhyme. You know, you come up with a rhyme. All right, no one's ever written a song along those lines. You know, it takes 2 to violate the first act of the Sherman. No, it just doesn't work. I can't even get it out. All right, so number 1 involves 2 parties. You can't violate Section 1 of the Sherman Act by yourself, internally in your company. All right? It takes a conspiracy. It takes an agreement. We'll look at that in a minute. Number 2, Section 2. Every person who shall monopolize or attempt to monopolize or combine or conspire with any other person or persons to monopolize any part of the trade or commerce among the several states or with foreign nations shall be deemed guilty of a felony and similar punishment. So, can you violate Section 2 of the Sherman Act by yourself? Yes, you can. All it takes is a person. Can you violate Section 2 of the Sherman Act with an agreement with someone else? Yes, either way. You can do it by yourself. You can do it with another person. You can violate Section 2 of the Sherman Act either way. And so what exactly is different? Well, what's different is Section 1 looks at behaviors that hurt consumers. Behaviors that hurt consumers. We're trying to protect in this, are we trying to protect small business? Is that who we're trying to protect in this? No. Sometimes we look at how one big business's behavior is going to affect a smaller business, but they're not really the victim that we're trying to protect. Who is the victim that we're ultimately trying to protect? It's the consumer. It's the buyer. We're trying to get the best price for the buyer with the belief in a free market system that if competition exists and buyers get the best prices, that we have the most efficiency in our system. And so it's an economic theory that says protect the consumer and everything else will work itself out. That we'll be most prosperous if the consumer gets the best price possible. Section 1 and 2 have the main provision. Section 1 requires 2 or more persons because a person cannot, quote, contract, combine, or conspire alone, all right? Unless you have multiple personality disorder, you cannot, and usually they don't come out both at the same time. So you'd have to do it in written correspondence. It gets awkward. So generally speaking, 2 people are required. And so Section 1 is concerned mainly with finding an agreement, finding some collaboration there. Section 2 applies to individual people or groups of people because it refers to every person. So each individual that's a part of a scheme or that by themselves schemes to become a monopoly and have monopoly power, that person is guilty of a Section 2 violation. And we'll look at next time we get together at how Section 2 is violated. At what point did we become a monopoly? What is this issue of market power, and how do we know when we've gotten there? All right? Because this is kind of hard. Is it the goal of every business to be the number one business in their market? It better be. I mean, if that's not your goal, if your goal is we're number 2, maybe you need to rethink your CEO ambitions. And so instead, everyone wants to be number 1. But there's a fine line between being number 1 and being the only one, getting rid of everyone else. You want so much market share that there's no room for anyone else. That's a monopoly, and attempts to create that are illegal under Section 2. All right, so Section 1. Section 1 regulates 2 kinds of restraints, okay? It regulates horizontal. This is one of those chapters where taking notes can really help you. And vertical restraints, because we're going to look at these on one slide at a time, but it's kind of helpful to see the big picture, okay? So I'll do what I can to try to map this out as we go through. So Section 1 regulates horizontal and vertical restraints. We'll look at each one of those in just a second. And so it classifies each kind of business behavior 2 ways. It says, first of all, is this behavior a horizontal restraint or a vertical restraint? And then number 2, it says, should it be analyzed as a per se, P-E-R-S-E, per se violation, or should it be considered as a rule of reason violation? Okay? A rule of reason. So if we give it a per se designation, then that means it is so bad and so anti-competitive you can't ever do it, and if you do, it's automatically a violation of the Sherman Act. So per se, bad. Can't do it, never can do it. If it's that kind of behavior, it's out of the ballpark. And we're going to look at a couple of them that are per se violations. Just can't do it. Now, most of the things we'll look at, most of the business behaviors we'll look at, are not per se violations, but rather have been moved into the rule of reason. The rule of reason says, well, it might look anti-competitive, and it might have the effect of hurting competition, but we're going to look and see if it's reasonable. And unless the restraint on trade is unreasonable, then we'll probably let it go. And so we go from per se, which is all the way to definitely not. You can't do that. No way ever. To rule of reason, which is it's probably okay unless you just get carried away and take it too far. Okay? So per se, rule of reason. All of these are going to be classified both ways. All right? Is it vertical or horizontal? Is it a per se violation or a rule of reason? Okay? So first of all, let's look at horizontal restraints. Now, let me ask you. If I'm going to use this diagram, seller, 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 buyer, buyer, buyer here at the bottom, is a horizontal restraint going to be, if I was to draw a circle that would represent the group of people that were involved in the horizontal restraint, would I draw the circle around all the sellers, or would I draw the circle around sellers and buyers? All the sellers. Okay, let's see if we're right. Yes, okay, good. A horizontal restraint would be agreements among sellers, or, by the way, could move the circle down and circle all the buyers, because that too can be sometimes anti-competitive, that restrains competition between rival firms competing in the same market. We say we want to have a free market so that it fosters competition. That's one of the modifiers on free market that we have as conservatives and as Americans. All right? The one and the same. If we're going to have a free market, it means that we are trying to foster competition. And competition means we're not working together. We're not working together. It means that we're not sharing information all that much. You know, there are people that say, well, I just want to get along with all my competitors and just want to be nice, you know. It really doesn't work. that actually can end up getting you in trouble. You can go too far with how nice you are, okay, and sharing information, price agreements, and so forth. You know what, you guys, I don't want to go head-to-head with you guys. You guys can have that market, and you stay over there, I'll stay over here, and we'll be fine, you know. And carving out territorial agreements, illegal, okay. And so horizontal restraints are agreements between sellers or agreements between buyers at the same level of the industry, okay? So let's look at a few of those. Let me just for a second show you vertical so you can have in your mind a contrast, okay? We'll come back to this. But a vertical restraint is when you start integrating the supply chain and you start wrapping up all the suppliers for you and then starting to bring more and more of them in to where nobody else can get the raw materials that they need in your industry. And so vertical restraints are when you start to integrate your company and have all the raw materials, all your suppliers, all your transportation, and all your outlets all in the same chain. You say, well, that's just good business. Well, yeah, at some level, but ultimately that can be a Sherman Act violation. All right, so horizontal restraints, vertical restraints. Let's look at some horizontal restraints as examples. All right, so horizontal restraint number one, price fixing. Price fixing. This is where we have an agreement. Remember, just going out with a sticker gun and labeling prices on goods is not price fixing, okay? Price fixing is when you get together with the competition and you say, let's set the price for these items at this level. And we'll both agree never to price it below that. These are usually for artificially high prices to keep the system up. So an agreement between competing firms in the market to set an established price for the goods or services they offer. And we say then, this is a per se violation. Does that mean there's any way we can say, well, but it wasn't an unreasonable agreement. You know, it was only for a few cents above the real cost there, the market price. And so it's okay, right? I mean, it wasn't unreasonable. Is there any way to analyze this according to reasonableness? No, it's a per se violation. Any agreement between competing firms about where we're going to establish the price, and it's price fixing. Now, have you noticed what I've noticed, that when you drive around town and you go to the gas stations, like all the gas stations have exactly the same prices on all the different things. And maybe sometimes in this town you might have like a favorite station you think is always 5 cents lower or something. But it's probably not, okay? How do they all end up with the same price even though we have this law on the books? Is it illegal to drive around and look at the signs? Is it illegal to send one of your people into the store and find out what the other guys are charging? No. Why? What's missing in that scenario? an agreement, right? There's no agreement. There's no negotiation. There's no collaboration. And so it requires there to be communication about it and an agreement. Price fixing, always illegal, can't do it. Number 2, group boycotts. All right. Now, group boycott says, all right, let's all agree not to sell to that buyer. Let's all agree not to use that transportation company. Let's all agree not to buy from that supplier. Any of those kinds of agreements between competing firms is called a group boycott, and it's illegal. You can't do it. So you hear in the news recently about the proposed gun control laws, right? And what was one of the reactions from some gun dealers? What did they say about that? The gun manufacturers, actually. They said, okay, fine, government. You're going to place all these limits and call us the bad guys. Oh, we're so bad. Guess who our biggest customer is, government? You. So you think we're so bad? Fine. We're not going to sell you your guns anymore. Oops. Go ahead, make your own guns, United States of America. Oh, you don't have a plant? That's too bad. We do. Too bad we're evil. All right. I love it. It's great. Now, can Browning and who else? Who makes the AR-15s? I don't know who makes it. Smith & Wesson and Beretta, that's probably Italian. Walther, that's German. HK, that's British. All right, so all these different gun manufacturers, can they get together and say, all right, let's agree not to sell to the state of Illinois? All right. No, because that's a group boycott. Now, they can personally say, I'm not doing business with you, right? And if there is someone out there that has treated the entire industry poorly, they could all just independently come to that decision. That's not illegal. What is illegal is agreeing not to do business. And so this one again, per se violation. We don't even look at, well, was it reasonable? Is it possible? No, per se violation, group boycott. All right, number next. Trade associations. Trade association. Put that on here. Now, what is a trade association? We have to look at that first. A trade association is just an industry-specific organization that we create in order to exchange information, business practices, represent the business interest as a lobbyist for laws, governmental bodies. We might do advertising campaigns together and look for regulatory standards to help us in our industry. And so let's say that we own a tech company and we create hardware for computers. And so are there trade associations that exist in the computer industry? Yes, okay. And one of these, for example, says to provide for exchange of information, representation of the business interest before government bodies. And so maybe one of the things we go to the government about would be, you know what, you guys are restricting the wireless spectrum, and we need a different megahertz range to create more powerful wireless, and we've created this network card. We need you. So we go to the government together, and it's for the good of the industry. That's fine, no problem. What about standards in the tech industry? What are some standards that exist in the technology industry? USB. You know, you guys never lived in the day when you had to reboot every time you plugged something into your computer, all right? I bought a game controller for my computer one time, and it was a serial port, which means that you can plug it in, but then you have to reboot before it will recognize that. There was no plug and play. That was the new terminology that came out with Windows 95. And everyone went, sweet, you guys laughed. That was a cool new product. It was awesome. We waited for like 3 years. And finally came out and everybody said, wow, you don't have to reboot. It's USB. And I said, what company makes that wonderful USB product? Well, what company is it that makes USB? Everybody makes USB. Well, how did that happen? You know, if you're the government investigator, you say, wait a minute, am I supposed to believe that you guys just all independently, on your own, without any phone call or any collaboration whatsoever, you're competitors, you're not supposed to be working together. No, they're allowed to work together to make standards in the industry that are going to help everyone. And so it used to be, what we have DVDs, and then what in your mind is the next step up of quality on a disc? Blu-ray, right? Is there any question in your mind in 2013 that Blu-ray is the definitive high definition video format? Okay, none whatsoever, right? Well, go back just 4 years, and that's not true at all. There are two competing formats, HD DVD, that's a lot of letters, and Blu-ray. And actually, HD DVD was the better technology, had a worse name, and lost because of it. Okay, so Blu-ray wins because it has the cool name, and everyone wants to be on the Blu-ray, all right? And so they win out, and that becomes the standard. But where was that? Was it some government somewhere that said, okay, fine, we're going to go with Blu-ray, pass the law. We did something this year, honey. No, it was the standards bodies that are developed that way. A new wireless standard is coming out that's going to be, even faster than a wired network, even faster than gigabit speeds. How do they come up with that stuff? Trade associations. Perfectly fine to get together, share information. Now, what's the danger? While we're here, the state of the industry is in a deplorable condition, and prices are just way too low, don't you think? And so NVIDIA and AMD get together and they say, let's keep our graphics cards prices up a little higher. I mean, are you kidding me? $50 for a gigabit? Come on, this is no way. And so they get together while they're there. Now that's a problem. That's collusion. That could be some of the other issues we talk about, price fixing and the like. Trade associations are analyzed under the rule of reason. And so we say, you can go too far when you're together, but if you're just together for these legitimate reasons, it's okay. What industry have you seen lots of advertising for without any specific brand name being mentioned? Milk, right? And who puts out the milk commercials? Which company? Yeah, what is that? It's a trade association. So all the farmers, all the dairy companies get together, they all throw some money in for the advertising, and it's generic to the industry. And what is their thought process? You know what? We can put different labels on it. We can say this one comes from Happy Cows, but at the end of the day, milk is milk, okay? And people really don't, do you really go into the store and say, hate to buy the off-brand milk, No, you look at two things. What is it, the 2% or the 1%, or which kind do I like? And what else do you look at? Price. No, what else? Well, okay, the price, but what else do you look at? The date. I hope you look at the date. Good night. You're going to be killed, This is important. All right. And by the way, little tip. Any of you ever worked in a grocery store? What's the tip? Where do you go? Pull it from? The freshest is in the back. That's right. Go for the back. So I'm always leaning as far as I can back into the back. I got long arms. I grab the last one out. 2 more weeks. It's still gone in like 3 days. I don't know what it matters, but it tastes better if it's newer. And so you care about the date. You care about the price. You care about it being the style that you want. I don't know what do you call it. The difference between 1% and 2. I don't know. Those are the horizontal restraints. All right. So we have rule of reason on trade associations, price fixing per se, group boycott per se. All right? Vertical restraints, we looked at this slide already. This is going to be any kind of collusion, cooperation between sellers, suppliers, buyers, retail outlets, transportation levels, things like that. And so those are anti-competitive agreements between firms at different levels, where we say, listen, supplier, you are just going to supply us. Say, oh, wait a minute, I hear about that all the time. Is that always illegal? Well, remember, this isn't the only thing we classify them as. Now, what's the second thing we look at? Is it a per se or a rule of reason? Okay? What you're going to find, just a little preview, most of these are rule of reason. Really, these are some of the only per se's that we actually have out there. So agreement between firms at different levels, vertical restraints can restrain competition. among firms that occupy the same level. So that's where all my rivals over here at these levels aren't getting this kind of deal because of some kind of shenanigans that I'm pulling in those agreements. And so vertical restraints that significantly affect competition may be per se violations, but as we look at in specific applications, most of them don't end up being that. By the way, the trend is every one of these, including trade associations, used to be a per se violation. So even though the Sherman Act hasn't changed since 1890 or whatever when it first came out, the application of it has. And so originally, all of this was completely prohibited, right? And the cases came one after another of companies getting absolutely dinged for that kind of behavior. But over the years, who decides whether or not it's a per se violation or a rule of reason, how we're going to analyze it? That's not in the law. You didn't see that in the law. I showed you the law. It didn't have that language. So who's deciding which rules to apply? The courts. And so over 120 years, they're chipping away at the protections of the Sherman Act by moving everything from per se category and analysis into rule of reason analysis where it ends up passing muster. So things today are done all the time that in 1920 would have been go to jail stuff. Okay? It's really getting less and less regulated. And this will be one of them, territorial and customer restrictions. If a manufacturer says to the sellers of its products, okay, you're going to be the dealer in this area, and I agree as part of this deal not to make anybody else a dealer within this county or this city. All right, what's an industry where you see that? Cars, right? Do you see a Nissan dealer across the street from a Nissan dealer? Usually not, okay? Why? Because Nissan makes an agreement with this guy, you're our guy. And so you be the seller in that area geographically, and we won't set up anybody else within your territory. Well, that's going to be looked at. It's going to be looked at. But it's going to be looked at under the rule of reason. And so what we're looking at is anything that would be unfairly competitive. We're going to look for, is there monopoly power all of a sudden coming in? If there's a line, if there's a row of car dealerships, like if you go over to Waukesha, where I bought my car recently, there are 10 or 15 car dealerships right in a row. Every kind of car you can imagine. Is there a problem for consumers having choice in that scenario? Really not. I mean, I got all the choices I want. Is my choice between one Ford Escort and the other Ford Escort dealer? Is that my negotiation point? Or am I really looking at, do I want a Ford Escort or do I want a Nissan, what's the equivalent? Sentra? Or do I want a Toyota Camry or a Honda Accord? And so I'm looking at competition that way, right? That's perfectly fine. Am I happy with that? Do I have lots of choices? Yes, and that means that we've hit the proper mix. If the other ones start to disappear, and now all of a sudden all there is a super dealer, and he's got all of the brands, now we might look at it differently. And so that's where the rule of reason comes in. You notice it's mushier, to put it in non-legal terms. Per se is nice. You're done. You're out. Third strike, you go to jail. Okay? Mixed metaphors. All right, so the rule of reason says, it's probably okay. Well, just keep an eye on that one. All right, that's kind of where we just ask, is it unreasonable? Let me write that one on the board. Territorial restrictions. And we'll call that rule of reason. Okay? All right? Number next, resale price maintenance. Okay? Now, resale price maintenance is different than price fixing. In a resale price maintenance agreement, we have some sort of a contract or agreement between a manufacturer and a distributor or retailer in which the manufacturer says, this has got to be the resale price. Have you ever heard the term MSRP? What's it stand for?
Manufacturer suggested retail price.
Okay. No, the S is important, right? The S is important. MSRP. What's the S stand for again? Suggested. Notice what's underlined in the resale price maintenance agreement is something when the manufacturer specifies a retail price at which retailers must sell its products. Is there anything wrong with the manufacturer suggesting the price? No. They're saying, look, they're kind of signaling, this is what it cost us to make that product. If you want to have a healthy margin and we want to keep the value of the brand up high, we all need to kind of shoot for this. And in some industries, the MSRP is a laughable joke. Nobody ever sells it for that. In some industries, that's just a starting point, and you actually get them higher price than that. Go out and buy a Prius, and you actually pay more than, quote, the sticker price. MSRP is oftentimes called the sticker price, right? And so you actually pay a premium because it's rare and it's valuable and people want it. Whereas you go to Kohl's, has anyone ever paid the amount on the sticker? No, it's just it's a suggestion, okay? It's what we use never, to calculate your savings. That's all they ever do. You spent $5 at Kohl's. You saved $400 a day. Wow, that's amazing. And so at the end of the day, it's a suggestion. Yes.
So how does Apple get around that? Because Apple requires the retailers to sell it on certain prices.
Well, it's going to be analyzed under the rule of reason now. It used to be a per se violation, and we're going to find out that now resale price fixing can be okay if it's done within limits. And Apple has stayed within those limits. Now, is Apple free of any kind of antitrust litigation? Oh no. They have a whole division, an army of lawyers that do nothing but defend them against antitrust cases, okay? And they're sued on it constantly, all the time. They're under a case or two or four. And so Microsoft, Apple, every tech company, that's just the cost of doing business, okay? So this used to be a huge no-no. You cannot do it. And then as recently as 2007, which I think all of you were alive in 2007, so this really is a recent development. Something happened. Now, a lot of times the cases that we look at are appeals court cases. We actually very rarely look at Supreme Court cases in this way. But today, we have this League in Creative Leather Products, which comes out in 2007 and changes how we look at resale price maintenance agreements. Okay, so here you actually have the company suing is part of the chain. All right, they're actually the supplier. So we go back to the vertical restraints page, and we had the circle around the thing. We had the manufacturers, and this is actually a reseller, right, inside the circle. And they're complaining about this being imposed upon them. Now, originally, they agreed to this, right? To become a reseller, they agreed that they would sell it for this price. And now they're turning around saying, well, wait a minute, that agreement was illegal. It was a restraint on trade. It's resale price maintenance agreement. So the trial court and the appeals court both upheld the law as it had been from 1890 up until 2006 by the time it got to there. And so they just did their job and said, well, 130 years of case law, that can't be wrong. And so they said this is a price maintenance agreement, it's wrong. The Supreme Court, on the other hand, turns around and says, you know what? It's time we looked at this differently. It's now okay for manufacturers to set minimum resale prices. Did they leave us any kind of guidance or any sort of rules along with that? Is League in Creative Leather Products the only creator of leather products? No. Are they anywhere near having market power? Are they the only supplier of leather products to PSKS? No. Are there other options for PSKS? Sure. And so the Supreme Court says, look, can we think about this again for a second? If we're talking about a small supplier that has less than 1% of market share, and they want to keep the price of their goods high to keep it exclusive, that's a strategy. That's a pricing strategy to say, you know what, we're going to be the premium brand. We're not going to discount. We're not going to put our stuff on sale. And you know what? That's exactly what Apple does. And they've said, you know, we're not trying to be the bargain basement. People will pay for quality if that's what they want. And we're good with that. And so people will know that it just works and that we are committed to it and they want that brand. And so we're not going to put our products on sale, period. And the Supreme Court says, you know, that kind of makes sense. We're going to let you do that. And so as long as there's not something else along with it, like monopoly power or abuse of consumers, then we're actually going to let you do minimum resale pricing. So this one has completely flipped since 2007. All right? Okay, let's put that one up. And we're going to say that that is actually, we'll just put okay, all right? And then we'll put okay, fine, we'll put rule of reason, even though we know that it's actually going to be just fine. Okay? I think this is the last of the vertical restraints, and it's called a refusal to deal. A refusal to deal. Unlike a group boycott, a refusal to deal is an action by one firm against another, and this is usually legal, unless the firm using the deal, refusing to deal, has or is likely to acquire monopoly power, and the refusal is likely to have an anti-competitive effect on a particular market. So this is where we say, Starbucks or somebody else says, okay, fine, we don't want you. We refuse to deal with you. And so they would say to Republicans, we don't want any Republicans in here. Can they do that? Yeah. Unless it's going to lead to market power, monopoly power. That's kind of the opposite, actually. Refusing to deal with someone to essentially on political grounds, on personal grounds, even on business grounds. That's okay, usually legal, unless we have monopoly power and it will have an anti-competitive effect on the market. So on this one, I'll just put special. Okay, there's a special rule here that says it's legal unless you have monopoly power and an anti-competitive effect. All right, so does your diagram look like mine? This is my summary of Section 1. You got your horizontal restraints, you got your vertical restraints. Under horizontal, you have price fixing, that's a per se. Group boycotts, that's a per se. Trade associations, rule of reason. Vertical restraints, we got the territorials, rule of reason. Retail price maintenance agreements, rule of reason, but probably okay. And refusal to deal, okay, unless we have monopoly power and anti-competitive effect.
So vertical restraints basically are a lot more fuzzy and there's not as much.
Right. Why? Because when we talk about competition, which way do we normally look? Out. We look horizontally. So if competition is the goal, as long as the other people in your field have healthy supply chains and they're competing against you on a fair basis, those are usually okay. There's a couple of ways you can go wrong, but for the most part, everything's fine. Don't confuse in your mind that somehow this says it's okay to say, we won't serve black people here. We won't serve disabled people here. We don't want any of those Hispanics here. What was the company that got in trouble on the Hispanic issue? Geno's in Philadelphia, okay? Said, wasn't it Geno's? They had the Philadelphia cheesesteak, the famous cheesesteak sandwiches. And they said, you must order in English. And if we can't understand you, we will not serve you. Okay. Well, the problem with that was there was kind of a backlash to the Hispanic community and this guy's political views about that you ought to learn English and integrate into society and so forth. And so refusal to deal has nothing to do with allowing discriminatory practices. If you are open to the public as what's called a public accommodation, meaning we open the doors and whoever comes in, then you have to deal with anyone on a non-discriminatory basis. By the way, most states now and most local communities have said that it is also violates anti-discrimination laws to refuse to deal with someone on the basis of sexual orientation. And so they've added that. Even though it's not been added at the federal level, it's been added at the state and local level. And you say, well, I'm going to be a Christian businessman and I don't want to deal with that, you may have to at this point. There's no exemptions for Christian businesses. Okay. All right, so this is my summary. That's how I'm visualizing it. If you have a different one, this is, I guess, a little different way to look at it. Next time we get together, we will do Section 2 of the Sherman Act, and then we'll do the Clayton Act, and then we'll do a few other recent developments, and how in the world does this work online? That becomes a very difficult question, and so we'll try to tackle that next time. All right, have a great day.